Yes, good evening to everybody, the students of the Moshi Cooperative University, the second year, second semester, if I not be mistaken over there, the subject is private international law, which I am going to deal now. And this conflict of law in tort, and tort, you know it, what is the connecting factor for the tort? What is the connecting factor for the tort? The connecting factor for the law of contract is lex loci contractus. That is a connecting factor. For the tort, connecting factor is lex loci delicti. How do you write it? I will show you here. Lex loci delicti. That is the connecting factor. With that, one can decide cases depending upon lex loci, L-E-X, I am writing the lex loci, L-O-C, lex loci delicti, D-E-L-I-C-T-I, delicti. This is the connecting factor. That means where the tort is committed. Answer is where the tort is committed, lex loci delicti. Dereliction or deliction means here crookedness or wrong, and lex loci, a place where the wrong is committed, means accident is made, any other accident or any tort. So that is a connecting factor for the conflicts in the private international law. Now let us see that, of course, I have taken from the Adarsh Singh Thakur, and he is a third year student of the Indore Institute of Law, and he discussed that concept of foreign tort and the various aspects of it. So I should be thankful to him, otherwise it will not amount to be a gentleman agreement from where I have taken this article. So now let us see what I would like to make it out in introduction. In tort, a man will be born somewhere, citizen of Tanzania, and he made a contract, he purchased a car, or he traveled to the India. A Tanzanian traveled to India for his business trip or to sightseeing. Because India is a tourist place, there are many sites are there where you can see it. Mouth is not a pen stand, nor a pen holder. It is clearly mentioned in the 10 Commandments. Old habits die hard, or old habits seldom die. Everything will be recorded here. So now, a Tanzanian went to the India either for the tourism or for any other reason, but he caused a accident over there. Tanzanian caused the accident in India, and the victim is, injured person is Indian. And definitely Indian will file a case. Either he may be a local man or he may be a visitor. And he filed the case in the Indian court. The Indian court has given the decision that, okay, 2 lakhs will be paid Indian rupees to him because his legs was injured and he was hospitalized and he was on the bed for the 3 months because plaster of Paris is put to his leg, and hence 2 lakhs compensation should be paid. But that fellow went in as a tourist, he doesn't have that much money, and he said, okay, the money is not with me, and it is proved over there, yes, it is a negligence on the part of the Tanzanian to cause a accident to the Indian person in India, hence the court has given the judgment. Now, how the judgment could be recognized and enforced in Tanzania? And I told you that Tanzania is having a good relations with that India in the mercantile, in the business, or as well as in investment also. So law of obligation will play, and hence they will intimate the matter to the Tanzanian embassy, which is there in the New Delhi, and the embassy will inform over here, and the matter will be sent to the High Court, and the High Court will register it, the judgment which is given in the Tanzania, and they will see that the Tanzanian who is having the estate here, either in the Mwanza or Moshi, wherever he may be there, think that it is in a Moshi and is a resident of the Moshi, so it will send to the Mahakama Moshi, and the Moshi High Court will register it and will notify to the person, yes, this much damages should be paid, 2 lakhs to the Indian where you have committed a accident in India. And hence, suppose if he could not listen, his property will be seized, his bank balance will be seized, the amount will be sent to the India through the court to the bank, respective bank, the plaintiff where he filed a case. And thus, the amount will be paid to the Indian, even though he did not come to the Moshi and the case is filed because his house is there in India. And there is a factor, is there connecting factor, that is the law of the forum. The law of the forum, chance will be given to the plaintiff wherever his residence is there, wherever it is convenient to him, he can file a case in that country, in that competent court. And generally the competent court for the accident case is district court. And the district, we will say in India session court, but here you will say is the district court only, because residence magistrate court mostly deal with the civil cases, only sometimes it will deal with the criminal cases. So district court will make it a decision, and the decision will be again confirmed by the High Court, because he will not go to the Court of Appeal, High Court. At that instance, that is a final judgment. If not a final judgment, High Court endorse it. Yes, it is a right, whatever the followed is the right, and they will endorse it. If there is no appeal would be there, that will be the final judgment in the Tanzania, in the India. When it is a final judgment in India, automatically the judgment will be, a competent court has given the judgment, such a judgment will be enforced, recognized and enforced in the court of law of Tanzania. Even though in the 11 countries, India is not there, but theory of obligation will be there, because such a cases many are there, because a good relation between one country to another country, even though they are not the member of the recognized enforcement of the act, where the only 11 countries are included, but not the India. But still, there are good business will be there with the India, by the Tanzanian, and hence the law of obligation will work over there. A natural justice will be prevailed over there, and hence it will be considered. Because no court will see if there is any injustice caused to, irrespective of the whether he is a state subject or a state person or he is a foreigner, doesn't matter. He is a human being. He is a human being. So definitely it will make a judgment, and the judgment which is made there in the India will be recognized and enforced in Tanzania by the High Court of the Tanzania, and it will be implemented. The amount will be sent to him by the bank transfer from the date of the accident till the amount will be claimed over there with the 6th, and India will say 7% the bank rate till the final payment will be made. That much amount will be paid over there. So why this thing would be happening? The reason is because of the globalization and liberalization. Now the world is on the palm. Morning breakfast, Uganda, chakula cha michana, chakoni chako. Najua chakoni chako? Uko wapi chakoni chako? Dodoma. Chakula cha michana Dodoma, na usiku Dar es Salaam. Auna hapa na Moshi. Woshi wapi kula? Crisp burger. Najua crisp burger. Naenda towards new bus stand. Crisp burger. It is a hotel is there, and chakula cha usiku pale kula. Okay, kula roge. Hamna matatizo. Kunywa kwanza pili kula. Au da kula na baadaye kunywa. Hamna shida. So what I am giving is, a man will be mobilized from one country to another country because of globalization, because of liberalization, because of Indian Tanzanian foreign policy. And if your good relations will not be there with the neighboring country, the country will not flourish. And hence, wherever the conflict would be there, what law would be applicable over there? And where the most connected relation with that country law would be applied over there. And another point is there. because cause of action happened in the India. Yes. Who did it? Tanzanian did it. Suppose if there is a cap, a ceiling would be there in the compensation. In Indian law, there is a ceiling would be there. Let us presume it. At that instance, the benefit will be given to the plaintiff either to follow the Indian law or to follow the Tanzanian law. Anyone. If the benefit is more for Tanzanian law, yes, Tanzanian law will be used as it is in India and the decision will be given. Because court wants to see that the plaintiff who comes to the court should not go with the empty hands. Number one. Number two, in the private international law, there is no hard and fast rule is there. Please note the point. There is no hard and fast rule is there in the private international law because the judge using his logic and see that the judgment will be given in such a way it is a justice to be given and justice seems to be given. A justice is made, justice seems to be made. So that way they will make it out. And hence they can use the connecting factor. They can use any one of the theory which is beneficial to the plaintiff. They can tap any method and they will give the justification stating that yes, this law would be applied over there and this theory would be applied or this connecting factor should be applied or this most connecting relations with the country which is having, even that can also be said. But overall, justice should be made and justice should be seems to be made. So this was the principle, they would adopt it and this we can make it out. So gist which I have given, and if you happen to read, yes, because only one person joined in my thing. Nicholas, can you unmute and read illustration? The illustration which I highlighted here. I enlarge it. Could you unmute and read illustration which is I am highlighting here? Haraka. Nicholas doesn't know how to mute or unmute. There is two buttons are there. Unmute. Papi naenda. Hapa matatizo. Is it a loose contact? No, mana saidia. Is it a loose contact? Yes. Yeah, which I highlighted it. And you could see on your screen also, on your mobile screen. Read loudly. Unmute and read. I said he's present over there because it will be, his voice will be recorded here automatically. Participant, Nicholas is there. Unmute and read. Who is Nicholas here? Who joined? Raise your hand. Unmute. Unmute and read. What done? You do it now. Because when you do, I would hear the sound here. Repeat. Say loudly. Read loudly. Hapana, your sound will not coming. I think that there is some matanda or matatizo. Okay, I will read it. A person, and who is a Indian visits Bhutan. Bhutan is a country. Bhutan is a country adjacent to the India. Bhutan, Nepal, Tibet, these are all the neighboring countries. Pakistan, Bangladesh, like here, we have Nairobi, Kenya, Uganda, Zambia, they are all neighboring country. So a Bhutan also neighboring country, and a Indian, who is an Indian visits Bhutan and there he commits a tort. Who commits a tort? Indian commits a tort. Against whom? B. Who is B? B is from Bhutan and who is a citizen of Bhutan. So here tort committed by A is a foreign tort. We can say it's a foreign tort because a foreign tort we will say at that instance only when the two countries will be involved over there. It is a foreign tort. Who committed? A committed. On whom? B. B is a Bhutan citizen and he is a victim. The wrongdoer is A. So now the B Bhutan, what he will do, because his house is there in Bhutan, he will file a case in the Bhutan. If the judgment of the Bhutan is given over there, naturally, if the Tanzanian having a good relations with the Bhutan, or the Bhutan a good relationship with the Tanzania, or law of obligation will work if there is no transaction between the two countries also. Because it's the injustice caused over there. Because a man with the fault of a Indian who visiting the Bhutan, and if he made such a mistake, naturally Bhutan should have to give the judgment that will be respected by the Indian, because the Indian did the thing. Indian did the thing, it will be respected, and the judgment will be recognized and enforced in India. Either you take India, or the act is committed by a Tanzanian. Either he committed it, or excuse me, or either he committed it or he was injured in any way. In any way, a case will be filed, then he will be entitled it if it is injured. If he is injured, he will be entitled to get the compensation. So that is the foreign tort, it is committed over there. Either you say India is a common law country, Tanzania is a common law country. Hence, either you read in India or you read in Tanzania, doesn't make any difference. So in Tanzania, the law of tort is not codified. Is it or not? Excuse me. The law of tort is not codified, and it is a judge-made law and made by the presidents, and we follow the English law, landmark judgments, and that is the way it is not codified. As a result, there is no statute or an act of the legislature which prescribes the unlawful acts and punishment for the same. Like in Tanzania Penal Code, it is specifically mentioned, if you commit this offense, this much punishment. It is codified. It is codified. But law of tort is not codified because it is based on the common law, precedents, and maxims, and depend upon justice, equity, and good conscience. Justice, equity, and good conscience. So based upon it, and hence there is no specific statutes are there. Thus the Tanzanian courts or Indian courts have to apply the principle of tort law on the basis of the English cases. So Tanzania case law, Tanzania tort law is based on the Indian tort law. Indian tort law is based on the English tort law. In other words, Tanzania tort law is based on English tort law. Is it clear? Tanzanian tort law is based on English case law, English tort law. Or we can say Tanzania tort law is based on Indian tort law. Then Indian tort law is based on English tort law. So you might have studied the syllogism in the legal methods. Man is mortal. Man is mortal, means die. Socrates is a man. Hence, Socrates is a mortal. A big premises to small premises, direct we can make the conclusion. Why you are looking at me as if that you think that I am teaching you? Syllogism is their legal method. Logic and legal reasoning is their subject. You already studied. Sir, we studied and buried. Studied and buried also, over. Okay, bury it, but keep something here which is needed. And chafu you can bury. Mawazo you can bury. Yeah. Say loudly. Come here and say, because it will be recorded. Jo. Say loudly here. Sima mahapana sema.
Okay. Yes, Professor, I have a question here.
Good.
On the ground of foreign torts.
Yeah.
What I know, when we speak about torts are about case laws, and there is no tort if we don't have case laws. Now, from there, I have a question now. On the matter of international issues, are there any cases which can be used as a governing authorities on the matters concerned with the tort? Or maybe there is a question, there is a dispute between the two people who have got the different nationality. Now, which kind of case law will be used in judging the disputes?
Yes. A case law is a case law based on the principle. When the general principles are common anywhere in the world, general principles are common anywhere in the world. So a case law is decided based on a particular statute, or based on a logical reasoning, or based on any maxim, or based on any theory. That case law never will be a wrong case law anywhere in the world. When such a case law is made over there, yes, the case law will be taken as a persuasive value to support our stand. Yes, it can be used over there, even though the case law belongs to the other country. In the law of tort that you might have read it, Donegal versus Stevenson. Kono case law, kono case law, snail case law. A ginger beer where a snail, rotten snail was floating over there when he poured the second time, but the jug is not transparent, it is opaque, you could not see physically. When she's consuming the second round and she saw the rotten snail and she vomited and she fell sick and she was hospitalized and some amount of compensation will be paid by the husband, not either husband or anybody who will be escorting her. And the court says yes, the neighborhood principle is there. Even though he is not a party to the contract, because the ginger beer is prepared by the manufacturer, and there is a principle, three principles are involved over there. Number one, love your neighbor. Number one. Number two, contract of privity is a fallacy. Number four, even though you are not a party to the contract, but you suffered it because of the negligence on the part of it, and hence, and there is no break of chain from the manufacturer to the bearer who served it, either lady or gent, whatever you call it, a steward or a waitress or waiter who served it, because the sealed bottle is opened in front of him. And hence, there is no chain break. Hence, that is the reason a manufacturer is held liable to the consumer. Even though there are many intermediate people are there, a agent is there, a distributor is there, and many other people will come, and in spite of it passing, and the last consumer is there. So a consumer got the victim because of the negligence and the part of the quality control people, they could not see a rotten snail would be there in the opaque bottle. So this is the foreign case law. But the same case law we can use in the all common law countries as an example. Negligence is developed from that case law. How do you say negligence? And what are the characteristics could be there? So a standard principles are there. Yes, it can be used. 2 into 2, 4. Is it only true in Moshi? Not true in Monza? Not true in India? Not true in Japan? 2 into 2, 4. In Kenya, it is 5. 2 multiplication with the 2 is 4. Is it 5 in Kenya? 6 in Uganda? Principle, equation. You need not to do the work. You only use the result. Yes? When principles are there, common law principles, a common principles based on it, a standard principle, a case is decided, yes, it cannot be untrue in another country. But all not the same. An offense of defamation in India is not defamation in Tanzania. Something will not be there. And here in Tanzania, adultery and prostitution is not an offense. Am I right? But now the Supreme Court has given the decision recently, 1 month back. Prostitution is a trade. A sex is a profession, You will give with the license. That's a very much bad. Oh, license is there. So you will visit India. Apana. Judgment is given doesn't mean that it will be implemented in total. That is a very wrong judgment. You should not make it. Shiri should be there. And we should not disclose it. And we should not make it a trade like a profession. And hence, there is not a good policy to make such a judgments, because such a judgments will be happen only in the USA, in an advanced country, because there marriage is a ordinary thing. They will say, Angalia hapa. Nini, chini nini. Keep your two hands on the table. Keep your two hands on the table. If you want to write from there. See, Janja Sana, notebook Ju, chini smartphone. Muhindia Janja, hapa muhindia chagga. Umepata? Don't make any tricks with me. I have seen the world. I taught in various places. I taught in the various places, in various platforms. Najwa, the psychology pulse of the students. Yes, coming back, a rule is a rule that can be applied over there. Is a precedent we can use as it is used over here as a persuasive value, plus that can be used as a good judgment, because the judgment is given by the common law country. And the common law countries follow the common law rules. And hence, it's a valid judgment. It is a valid judgment. Because the judgment will not take away any breaking of the rule of the existing laws, statutes, policy of the government, constitution. When such a thing is there, why you should not use that same country law judgment in our laws? Because it will not a harm. It's not causing a harm to anybody. And hence, justification will be given over there. So that is the thing where the foreign law is concerned, if any law is concerned. But the two things are, they made it. That is a tort of reality. That is the one thing. And another thing is tort of personal torts. Tort of reality in the sense, if you commit a trespass to the immovable property, foreigner, an action cannot be taken. Immovable property. Suppose somebody's land is there, and you enter into the land without the permission of the landowner. Is a trespass to land. Yes, the person cannot file a case to the Magani, that is a foreigner, in the court of law. The court of law says he is a Magani, he doesn't know. But Kila Siku, every day he is making a trespass, the bad intention would be there. Yes, he will be penalized. And at the time, they will write a letter to the embassy. Your Tanzanian person coming Kila Siku Hapa to see what he want to see. So that was the thing, and it will not be an excuse, even the trespass to land is concerned. But trespass to person is concerned, yes. Suppose you entered somebody's room and you have taken some electronic item from there. So taking the electronic item is a movable property. It is not trespass to immovable property. It is a trespass to movable property. At that instance, yes, he can be challenged there, and if a case will be filed against the Magani in India, or a case will be filed in Tanzania if any Magani has taken any property from Tanzania. Tanzanites. What is the place? Marareni, Mirareni. Mirani. Okay, Mirani, Pembeni to the Kia. The Kia airport, Nakulia, Naenda Pale, Barbara Naenda Pale. So, Tanzanites, if you are stolen from there, from the mine. Who? Magani. Yes, it is a mobile property you have taken. But if you entered into without the permission of the mine, that you made the trespass to land, which is immobile, and hence you can be excused. But Tanzanite you taking over there, yes, it is a mobile property, a case will be filed against you. They need not to, because the theft is done, and you can write a letter to the Indian embassy, because you are Indian, has stolen the Tanzanite here, what should I do? Then they will say, do as if he is a Tanzanian. The same law would be applicable here. Do you think that for foreign people, the foreign law would be applicable here? Hapana. Like a subject over here, the same law would be applicable because the law of the land should be applied over there. The same punishment would be there. Hence, for the real property, yes, a action would be taken against you. An action will be taken against you for the real property. And what law should be followed over there, I told you, generally, where the case is filed, that country law would be followed. Where the case is filed. And another point is, suppose if the case is filed there, compensation is less. And if you follow the Tanzanian law, the compensation is more. At that instance, the plaintiff, Janjasana, he will say, let the substantial law of the Tanzania would be followed over there because it is the Tanzanian who's committed the crime. Let the Tanzanian law would be followed or something. So if there is no cap and that compensation more in the Tanzanian law, legal system, at that instance, the court will follow the Tanzanian law and pay the compensation more. Because if the Indian law is passed over there, the compensation is less. So they will give the advantage of the legal system of the other country. The benefit will be given to the plaintiff. The plaintiff benefit will be given to the plaintiff and who files the case. So that may be that. But a general rule is there. Whenever you file a case in a particular country, procedure law of that country should be followed. Regarding substantial law, lex causae, connecting factor. Lex causae, which will be the benefit, which will be the most connected, that country law would be used over there as a substantial law. At that instance, the court having the discretion whether to follow the law of the forum or they will follow the law of the loci, means lex causae, other country law. At that instance, the terminology says that lex loci will be replaced by, lex fori will be, lex fori means the law of the forum. Lex fori will be replaced by lex loci. Lex fori means law of the forum will be replaced by lex loci means lex causae, where the cause of action made by, where the right is made over there, that country law could be used over there. Because that country law gives the benefit to the plaintiff. That is the gist of it. So his personal tort means either you make assault, battery, or any other trespass to person or to the property. There we can say personal law. And here which I given the illustration. Oh, Ametoka, you log off. Okay, Amnashida. So the illustration is concerned, A, within parentheses, a resident of Spain on a trip to Switzerland and got his phone stolen by B here in Switzerland. Since the phone is mobile property, such a tort will fall in the category of the personal tort under the foreign torts, and the suit filed by A will be accepted by the court and B will be held liable. A, resident of Spain, he is a foreigner and he made a trip to Switzerland and got his phone stolen by B, a citizen of Switzerland. And since the phone is a mobile property, such a tort will fall in the category of the personal tort, and hence it can be filed in the Switzerland, and whatever the punishment would be there, whatever the compensation would be there, Switzerland, that will be paid to the Spain, that is the resident of Spain A. It is like the same manner, like the local people have stolen, or the local people of how they will be given, the same treatment will be given for the foreigners also. So that is the one example. And another example which I cited here, illustration is K, a resident of China. A K is a person, he is a resident of China or a citizen of China, nationality of a China, or he hails from China. While on an internship program in Singapore, he went for the internship to the Singapore. Singapore is another country, China is the another country, and assaulted B, and he assaulted B. Here, since the tort was committed against the body of K, and it will be personal tort, and suit filed by K will be accepted because he is a Chinese and he was attacked by the Singapore B, and hence it is a personal tort and it will be accepted by the C court, accepted by the court, and B will be held liable because B is the person who is the wrongdoer. So that was the thing. For the personal tort, yes, a case will be filed. For the immovable property, generally the case will not be accepted. If it is repeatedly done over there, then a case will be, yes, definitely it will be registered. The condition as follows: the wrongful act is actionable in the country where such wrong has been committed. That is another case law. Suppose if it is a wrong there and a people acted, at that instance, it's not a tort. The landmark case is there, Phillips versus Air. That is a landmark case. The wrongful act is actionable in the country where such wrong has been committed. The first condition which has to be fulfilled in the case of personal tort to be successful is that tortious act which is committed by the defendant against the body or the property of the plaintiff is actionable in the country in which this act has been committed. And for example, if a tort is committed against A's body and he files a claim for the damages, the court will first see whether the suit can be filed in the court of the country where such an act was committed or not. If such an act is not actionable, then suit filed A will be rejected. For instance, in Tanzania, prostitution case will not be actionable. Of course, that comes under criminal law. If Tanzania a case is not actionable, at that instance, the other country, if a man files a case, it will not be accepted because it is not an offense in the Tanzania. If it is offense in the Tanzania, yes, it can be filed. That is the gist of it. So the landmark case law is there. This is a Phillips versus Air. That is the landmark case law. Let us see that how it can be done. It is Hume's bench. They are not supposed to write that like this. I told you, I don't know whether I told you or not. Square bracket, one should have to use it, and circular bracket, one should have to use it. For the year, you cannot use any type of the bracket for the citation. I don't know how many would follow it. You cannot use the bracket of your own choice in the citation. No, there is a rule. There is an equation. If any report or reporter having published in the volumes, then such a reporter year should be in the square bracket. If any reporter which is not in the volume, which is not diminishing chances for your marriage, I told you, your face is like that only. Again you put, I removed from here, again he put from here. Why do you keep, it doesn't have a vertebrae. Sir, vertebrae ipo sir, but asubi impakana kahapa hapa, then nachoka. Again she put it. Either she puts like this or she put like this. Okay, I don't mind, you can keep like this. Okay, Amna Shida. Amna Shida. But not Apana. So look at me. So now coming, this Phillips versus array, the plaintiff has filed a suit against a defendant who was the governor of Jamaica. So plaintiff, to my knowledge, from England, and the defendant from Jamaica. Najwa Jamaica. Jamaica is the capital of which country? Jamaica is the capital of which country? Huh? Sir, we don't know that capital of Tanzania, still we remember that Dar es Salaam. But somebody told me that capital of Tanzania is Dodoma. Please have some general knowledge also. Have some general knowledge also. In addition to that, study You have the other knowledge also. It's a must. Jamaica is the capital of Kingston, and the Jamaica Law of the Sea, a big study center is there. Law of the Sea, a big study center in Jamaica. So now this man is from Jamaica, governor he is, Jamaica, because the defendant had falsely imprisoned him. So the plaintiffs say defendant governor has imprisoned him. So now what the defendant contended that, means governor of the Jamaica contended that he had done in pursuance of an act of the Jamaican legislation in order to suppress the rebellion. So he's creating a riot over there. He creating a, rebellion, waging war against the state. He revolt the policies of the government. So he's creating a rebellion over there. Means he's creating a not nuisance, more than nuisance, means war against the nation. Something he is creating over there. Who this man Phillips and pursuance of the act of Jamaican legislature in order to suppress the rebellion. Yes, the Jamaican governor may imprison a person. A governor of the Jamaican government, he can imprison person because their law allows him to imprison a person who is motivating the rebellion or causing the rebellion, and you doing the act of a rebellion, you doing the acts against the state. Yes, a governor can, by the legislation, as per the Jamaican rules, he can imprison a person. So when such a thing there, it was held. What was held? It was held that since such an act was not actionable in Jamaica, because he is having a right to imprison it, so such an act is not amount to the false imprisonment. And the place where the act was committed, he is the rebellion in the Jamaica, and is a foreign national. And when an act is committed over there, at the time he is imprisoned. Yes, he is imprisoned because the legislation allowed them in Jamaica to imprisonment for the rebellion, and he did it. So therefore, the suit filed by the plaintiff, who is a foreigner, and could not be accepted, as thus the defendant was not held liable. So governor of Jamaica is not held liable because what he did according to the legal system over there, according to the statute, and hence he cannot be held liable, and he could have a right to do so. So that is the same thing which is made. He accepted, and thus the defendant was not held liable. The court accepted is what he did according to the law of the land. According to the law of the land. So it can be made. So it is not amount to any. So in the above case, it was observed that suit for a wrongful act cannot be enforced only if such an act is not actionable in the country because of no recognition being provided such a right. Suppose it is actionable in that country, yes, a suit can be accepted where it is committed. But if there is any limitation place an act from being actionable only on ground of the procedure, then such an action can be actionable. Suppose law of limitation, law of evidence, Criminal Procedure Act, Civil Procedure Code, IPC. These are all substantive laws or procedure laws. Sir, we don't know what is the substantive law and what is the procedure law. The gentleman who sat at the back, I don't know whether he sat for my class or he is sending the SMS. The striped shirt man, look at me. He is not look at me. Raise your hand, keep on the table. Raise your two hands. Where is your smartphone? Don't send any messages when you are in the class. If you are not interested, you can TOKA, T-O-K-A. Don't create the nuisance in the class. This class is to listen and ask the questions, not to send the SMS. Sir, more urgent. What more urgent? If more urgent, go out and do whatever your business. I don't ask you, come again. Are you following me? Please don't draw my attention. So now because if you draw my attention, I already told you, my tongue is tied, my hands are handcuffed, my legs are fettered. Bouncer, I already gave the explanation. Hands are handcuffed, tongue is tied, legs are fettered, F-E-T-T-E-R-D, fettered. You know, animal which will run away, what do they do now? For foreleg, one rope, for hind leg, one rope, short rope, they will make it out so that it will not run. It will go like this, like this. So I cannot move. So let us come to the point again. Law of limitation is a procedural law. It is in Tanzania as well as India, and most of the part of the what, except a few parts they will say substantial law. And the law of the evidence is both substantial law as well as the procedural law. But we consider it as a adjunctive law, but we'll consider as a procedural law only. But its specific name is there. Adjunctive law. A-D-J-U-N-C-T-I-V-E. Adjunctive law, not adjective law. It is both partially. IPC is a substantial law. So, where a case is not filed because of the law of limitation, the law of limitation is not the criteria. Such case can be filed in the court. In the law of limitation, you cannot file a case in Tanzania if it is a contract more than 6 years. If more than 6 years are there, you are not supposed to file a case in contract. Do you think the right is gone? No. Right is barred because of limitation. But the remedy is barred because of the limitation. But the right still exists. The due is due. If you don't clear now, at least you clear in the heaven. Are you following me? Did you get my idea? The right is there, but remedy is barred because of limitation. But such a case in private international law, they say it can be excused. If any case is barred by the limitation, it will be accepted in the private international law because other person is a foreigner, and hence exemption will be given for the procedural laws. So it can be filed. Did you get an idea? Okay, let me presume that you got an idea over here. Now let us see the further. If A is wrongfully detained, illustration I am reading. If A is this, which I have highlighted here. If A is wrongfully detained in another country and he could not